Today we're going to talk about the emergency legislations. What's the meaning of emergency legislations? Emergency legislations are an exception to the rule of the legislation that we took before. We agreed before that the legislations are mainly made by the Parliament and exceptionally in the subsidiary legislation, which are tiny details of application of laws, might be made by the government. In this case, the emergency legislation, the exception to the principal rule that legislations are enacted by the Parliament, exceptionally in this case, the President is going to enact these emergency legislations. President may enact ordinary legislations or issue decrees that have the same effect and force as the laws enacted by the People's Assembly or by the House of Representatives only under 4 conditions. First of all, from the name of the emergency legislation, there should be a state of emergency. So what's the meaning of state of emergency? Number 1, that there's a necessity and urgent issue that has to be dealt with without delay. So this means if the President is not going to be able to take this exceptional measurement that is called emergency legislation, there will be a huge bad impact on the state. So this is a very urgent matter that requires that the President must take a certain decision. The urgency being left to the discretion of the President himself. So who is going to say whether there's a dangerous situation or there's a necessity or there's a must to interfere? The President by himself. Okay. What are the cumulative conditions also required for the interference of the President to enact this emergency legislation? Number 2, that the House of Representatives be in a recess or in a state of dissolution or in a state of a suspension. First of all, what's the meaning of recess? Recess means like holiday. So the House of Representatives doesn't go on sessions in the whole year. They take rests and holidays in between. So if an urgent matter occurs when the House of Representatives is on holiday, the President is allowed to enact emergency legislations. The same goes if the House of Representatives was dissolved. What's the meaning of being dissolved? Being dissolved means that this House of Representatives doesn't exist anymore. It was dissolved by the President, and yet the new elections by the people wasn't done yet, so there's a gap. Now we do not have a current House of Representatives. This is why in this case, in case of emergency, the President will be allowed to enact the emergency legislations. And the last option of absence of the House of Representatives is being absent temporarily. How? This House of Representatives exists but cannot convene for a reason. They cannot meet in session. Now, there's a reason that prevents them from going on session. Like, for example, when the first revolution in 2011 happened, during the 18 days of revolution, the Parliament or the House of Representatives couldn't go to it to convene in sessions. Number 3, that such decree is submitted, discussed and approved within 15 days from the first meeting after recess. So this is very, very important. Again, exceptionally, the President was allowed under certain conditions to do an emergency legislation, but yet this is not his prerogative or function. This is why whenever the House of Representatives will be able to convene again after coming from holiday after recess or after electing the new House of Representatives, if the House of Representatives was dissolved, or after the disappearance of the reason of suspension, whenever this House of Representatives will come, then he must discuss in the first meeting this emergency legislation that was taken by the President before. This decree, presidential legislation, must be submitted, discussed, and approved within 15 days or in the first meeting. Okay, so here the House of Representatives came, and now they are going to vote on this emergency legislation. What are the scenarios we're having? First, let's have a hypothetical example to understand. Assuming that during the first revolution in 2011, in the 18 days, the President Mubarak took an emergency legislation, that is, anyone who is going to protest, okay, in the streets will be taken into jail. And the House of Representatives was suspended at this time. So, when the revolution ended and the House of Representatives, okay, was dissolved and we had a new House of Representatives, this House of Representatives to vote on this emergency legislation that was taken exceptionally by the President. So here we have three different scenarios. The first scenario, that this House of Representatives is going to reject the whole emergency legislation made by the President. So in this case, if the Parliament didn't approve the decree, it will be cancelled retroactively, which means in this case that the prisoners, the one who protested in the streets, they will be released immediately. So here the emergency legislation is going to be stopped in the application in the future, and also the effects of it in the past, we are going to erase them. This is option number one. Option number two, that the House of Representatives is going to reject this emergency legislation in the future, but will remain the effects of the emergency legislations in the past, which means that we are talking about what we call immediate cancellation. What's the meaning of immediate cancellation? It means that in this case, President Mubarak, when he put in jail people protesting against him, the Parliament is going to keep the one who were kept before in jail, but in the future they are not going to apply this emergency legislation. So if anyone is going to protest, they won't be taken into jail. And then we have the third basic scenario and simple one. It's the total approval on the emergency legislation, which means they totally approved of the effect of the emergency legislation in the past, and yet they are going to apply it in the future. Moving on to the revocation of the legislation. First, what's the meaning of revocation of legislation? Revocation means cancellation of legislation. How can we cancel a current legislation? We have two ways and two forms of revocation or cancellation of legislation. The first one, that is very, very simple and can be easily understood and concluded, and the other one is indirect. So the explicit revocation is a direct way to cancel a certain legislation, while the implicit revocation is an indirect way to cancel a certain legislation. First, let's talk about the direct one, the explicit revocation. How can we have an explicit revocation? There's a provision determining its enforcement for a certain period only, then the lapse of this period would mean an explicit revocation. So option number one, that the law itself states when it's going to be applicable, and it states after a certain time or after a certain duration the law is going to be cancelled. So there's a reference in the law itself and a certain provision stating when it's going to be cancelled. This is the way number one in the explicit revocation. Option number two, that we have an old law, okay, concerning a certain matter, and then we have a second law that was then enacted later on that states clearly that it's going to cancel the previous legislation. And then we have the second indirect option of revocation, which is called implicit revocation or implied revocation. It's the same. How can we have this implicit revocation? When a new legislation is enacted, including a provision that contradicts the old one, for the enforcement of both is impossible, and the new intent of the legislator has the priority over the old intent. So here basically we have the law itself. It doesn't provide a period when it's going to be cancelled, okay? And then we do not have a new law stating clearly that it's going to cancel the previous law. So what's the scenario we're having now? We have a current legislation, okay, that states something, okay, and later on there's a new legislation that talks about the same object, the same content of the law, but we have an obvious contradiction between law number 1 and law number 2. So this means that the law number 2 comes here to implicitly cancel the old one. We are going to move to examples to understand the difference between explicit revocation and implicit revocation. Examples. The explicit revocation. All universities will be on holiday till the end of the war. So here the legislation explicitly stated that the universities will be on holiday when the holidays will end at the end of the war. So here the legislation itself states its explicit revocation, which is after the end of the state of war. Okay. Moving on to the implicit revocation. We have the old legislation stating in Article 9 that all GUC students must arrive at 9 a.m. And later on, Article 30, that was enacted after Article 9, after a certain time, we have this law stating all GUC students must arrive at 8 a.m. Okay, let's give some notes related to this implicit revocation. Number 1, in the Article 9, did we mention anything related to when this law will be cancelled? The answer is no. Number 2, does the new legislation in Article 30 refers to the old legislations and said exactly that the old legislation will be explicitly cancelled? And also the answer is no. So what can we notice if we compare both the old legislation and the new legislation? We are going to see that there's an obvious contradiction between both of them. Both they talk on the same object. It's when the GUC students must arrive to the campus, and both we have obvious contradiction between them. So this obvious contradiction, whenever it arises, this means that the new legislation here will come and will implicitly cancel this old legislation. So as a consequence to this new legislation, the GUC students, they are going to arrive, they must arrive on campus at 8 a.m. and no longer at 9 a.m. Another examples for the implicit revocation. A new legislation is enacted and includes a provision that is in absolute contradiction with the previous legislation. So another example, if we have, for example, Law 1, the driving age in Egypt is 16 years old. This law was enacted, for example, hypothetically in 2015. Law number 50 that was enacted in 2020 states that the minimum age of driving in Egypt is 18 years old. So here there's an obvious contradiction between both of them, and this means the cancellation of the previous one of the law allowing people to get their driving license in Egypt at the age of 16 years old. Another complicated example to show you the meaning of implicit revocation is the Article 45 of the revoked civil law, which provided that ownership of assets, whether fixed or movable, fixed assets like the apartments, okay, or buildings, movable like the desks, laptops, and cars, shall be transferred by the mere conclusion of a contract of transfer of property so long as the asset is owned by the proprietor. But in 1923, the law of registration was enacted, and it provided that transfer of fixed assets might not be effected except through registration. That is, they may not be transferred by the mere conclusion of contract transferring ownership. Consequently, a contradiction arises between Article 45 of the Civil Code and the above-mentioned law of registration only with regard to the transfer of fixed assets. So what happened here, that previously we had a law that states that the ownership of whether you have a fixed or movable asset is going to be directly transferred whenever there's a transfer of property. So whenever you are going to sell the fixed or movable asset, and this has been the property has been transferred to the buyer, at this stage, okay, it will be owned by the proprietor. But later on there was an implicit revocation extra condition that was added and revoked a part of this old law only with regard to the fixed assets. So the fixed assets are no longer going to be transferred to the proprietor unless there's also registration of this fixed asset. So here we have a partial implicit revocation in this law. Another example that also is a bit complicated, so just to make sure that you understood this part. Long time ago, when we had in France, okay, we had the legislation is enacted completely organizing a certain situation, no divorce in France, for which a special legislation was previously enacted in the Napoleon Code. An example of this case is the law enacted in 1816, which annulled divorce in France, for it automatically revoked all the provisions of Code Napoleon that governed the rules of divorce. So here we had in France long time ago a whole book, okay, and a whole book which was called the Napoleon Code, that was talking about the cases of divorce, the conditions, and the consequences. Later on, there was a new law that annulled, that cancelled the option of getting divorced in France. So this new law is going to implicitly revoke the Napoleon Code that was organizing the whole cases related to divorce. And then we have rules related to the revocation of a specific rule and a general rule. So whenever we have a general rule and a specific rule is always revoked by a specific rule, and a general rule is always revoked by a general rule. Example, if we have a general rule stating Article 5, all GUC students must arrive at 9 a.m. And then we had a specific rule that was also enacted stating that all GUC management students must arrive at 7 a.m. If later on we had in Article 15, for example, all GUC students must arrive at 10 a.m., is this going to be applicable on management students? The answer is no, because as I told you before, whenever we have a general rule and a specific rule, the specific rule will remain an exception and will need another specific rule in order to be revoked. So if we want to revoke the specific rule, in this case all GUC management students must arrive at 7 a.m., then we must enact a specific rule dedicated to management students.
So now we are going to start an application or a classwork to what you have just heard in the tutorial. So I will read the question and then I will give you 30 seconds to think about it. So the answer here in the first question is false. It's false because the first condition in the emergency legislations that the president has the right to enact an emergency legislation or a presidential decree is only when the House of Representatives is in a state of dissolution, meaning that there is no House of Representatives at all. So, and second condition, that there is an emergency and necessity. Second question, the emergency legislations enacted by the president have the same force of ordinary legislations enacted by the House of Representatives. The answer here is true. True because the emergency legislations are decrees or laws made by the president on behalf of the House of Representatives, meaning that the president enacts legislations under certain circumstances instead of the House of Representatives. So, yes, it has the same force and same power. It is considered an ordinary legislation as well. Third question. If the parliament is in a state of dissolution, the president may intervene in cases of necessity. Yes, it is true, but to be more accurate, if the parliament is in a state of dissolution, the president may intervene in cases of necessity and emergency. So the president may intervene, meaning that he will enact presidential decrees or presidential legislations on behalf of the parliament, but also when the parliament comes back, or when we have a parliament after the elections, they have to look in the legislations made by the president. They may approve it or reject it. So, first question here, if such decree, the presidential decree was submitted to the parliament but not approved, it loses its force as a law? The answer here is true. True, because if the parliament rejected the decree, then it's no longer part of the ordinary legislations. It will be cancelled, and in most cases it's cancelled retroactively بأثر رجعي, meaning that any results or anyone that went to jail because of this presidential legislation will come out of jail. So, true, if not approved, if it is rejected, it's no longer a law. But if approved, it will be part of the ordinary legislations. Second question. Decrees enacted by the president are always bound by the Constitution. The answer here is true. True, because the presidential decrees, do you remember the degrees, the levels and degrees of legislations you studied previously? The highest level of legislations was the Constitution or the basic legislation, followed by the ordinary legislations made by the parliament, and lastly the executive regulations or the subsidiary legislations made by the government. So any ordinary legislation will be bound by the higher level, which is the Constitution. So the presidential decrees or the presidential legislations are made on behalf of the parliament, so they are the same level. So it will be always bound by the Constitution. Last question. Presidential legislations or decrees are not bound by legislations enacted by the House of Representatives. So, the answer here is true. They are not bound by any previous legislations made by the House of Representatives. Why they are not bound? They are not bound because they are the same level. So, today, if you have a rule that says if you throw rubbish in the street, you have to pay a fine of £10. Can you change it tomorrow or no? You can't change it by another law from the same level. If it is an ordinary legislation, then the Parliament may enact a new ordinary legislation that will cancel the old one. If the £10 are as an amount, they are not effective, everyone is throwing rubbish on streets, then if you make it 5,000, maybe no one will throw. Okay, so you can always amend laws as long as they have the same level. But you cannot amend, or you will always be bound by the higher level, which is the Constitution. Meaning that the Parliament or the President, they cannot enact a law that is not bound by the Constitution. Now we are going to start another question. The President may enact emergency legislations under the following conditions. First condition, there is a case of emergency and necessity, that there is something urgent that has to be, or an urgent situation that has to be dealt with without delay. Second condition, the Parliament is in a state of dissolution, that we have no Parliament. Third condition, the decree issued should not violate the Constitution or the basic legislation. Why it should not violate the Constitution? It should not violate the Constitution because it is the highest level of legislations. Such decree must be submitted, discussed, and approved by the House of Representatives within 15 days from their first meeting. Now, let's start an application to the previously explained part, revocation, or in another wording, cancellation, how to cancel laws. An old general rule shall be revoked by a new general rule. Is it true or false? An example to a general rule. Let's assume we have a rule or a law that says to get a driving license, you must be 18 years old or more. It's a general rule, it applies to everyone. If we have a new law today, to get a driving license, you must be 21 years or more. Can we keep both laws? Of course not. So, the new law will revoke the old law. The new general rule will cancel or will revoke the old general rule. So it's true. Number 2, an old special rule can be revoked by a new general rule. Let's begin with the general rule. A general rule that says to get a driving license you must be 18 years old or more. And there was an old special rule that says all women cannot drive. Now we are going to change the general rule. The general rule now is to get a driving license you must be 21 years or more. What will happen to the old special rule? Can women drive now? No. So an old special rule cannot be revoked by a new general rule. You have to understand that the special rule is always more powerful than the general rule. It stays as it is. Nothing can revoke it except a new special rule. Number 3, an old special rule can be revoked only by a new special rule. True, as explained. If we have an old special rule that says all women cannot drive, to revoke it, we must enact a new law that says all women can drive. Number 4, an old general rule can be revoked by a new general rule. An old general rule, all imported cars must pay customs. And you have a new special rule that says all the special needs people's cars are exempted from customs. So now, the new special rule can revoke the old general rule? Yes, it revokes part of the old general rule. Why? Previously, before the new special rule about the exemption of customs, previously it applied to all cars, all imported cars. Now it cannot apply to all the imported cars. It will apply to all the imported cars except the special people's cars.